Hey, what's going on, everybody? I am Uncle Sam, and welcome back to Freedom Ain't Free. This is episode number 363. And we are still covering our first 10 amendments of the U.S. Constitution, also known as the Bill of Rights. So today we are going to be digging off into Amendment 4 and Amendment 5. Let's get into it.
Freedom ain't free. Let's make 'em pay.
Brought to you by Uncle Sam Presents.
Okie dokie. So let's go ahead and pull these up. I'm going to do a little different this time. I'm going to bring them right here on the screen so you can. Okay. So we have at the top, we have Amendment 4. That's going to be the right of the people to be secure in their persons, their houses, their papers, and effects against unreasonable searches and seizures, and shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, you notice it starts off with to be secure in their persons. That is personal autonomy, freedom from unreasonable physical intrusions on the body. In other words, hands off without a warrant or probable cause. However, there's always a however. There have been certain carve-outs for officers in need to violate a person's personal space, as long as they have reasonable suspicion, which is a lower bar than probable cause. The police can legally pat a person down while being considered part of investigating based on specific facts. Of course, the authorities had to figure out a way, just like in many of our Bill of Rights, to subvert rights that are supposed to be given by God and protected by our government. We can take a look right here. I've got a little bit of this information already in a Google Doc. Pat Downs, the Terry Stop-and-Frisk Doctrine. The key case, Terry versus Ohio. The court created a category of police citizen encounter that is not full search in traditional Fourth Amendment sense, therefore doesn't require probable cause or a warrant. It requires a lower standard called reasonable suspicion. So reasonable suspicion means specific articulable, anyway, certain facts, not just a hunch that criminal activity may be afoot. If a frisk is involved, the person may be armed and dangerous. This is a deliberately lower bar than probable cause. The logic of the court used officer safety during the breeding investigative stops justifies a limited protective pat down of outer clothing. It's not in full search of evidence, just to check for weapons. But so there are guards and guardrails and guidelines inside of that. But man, there's always going to be some reason that, or some way that they're going to find a way to invade your space if they really want to. They're going to. Let's see. Next would be considered our houses, papers, and personal effects right there. Hopefully we all know and understand that if an officer does appear at your home investigating a crime, especially one that it seems that you are suspected of being involved in, then sternly and politely request and require a warrant before allowing them to gain entry into your home. This is for your own safety. Do not allow them to bully, subvert, or persuade you. You never know what could possibly be used against you. When you require a warrant, there will be rules of that warrant, and it is up to the officer to stay within its purview, or attain an attorney, or an attorney could get evidence thrown out in a court of law. Okay, so now I'm going to tell you a quick little story. One day I was sitting in my apartment and I was minding my own business. My roommate was asleep in his living area, and there's a knock at the door, and I'm like, dang, that sounds like a cop knock. And I get up, I look out the peephole. There's nothing there. It's just a thumb or a finger over the peephole. And I start to look out the windows, and I hear police department. Like they're yelling. I'm like, oh crap. And so I was like, I didn't know what was going on. And so from previous encounters in my life, I remembered I grabbed my keys and I grabbed my ID and I started heading out the door. And as I'm heading out the door, they're asking for my roommate, but it didn't matter because I'm shutting the door and I'm locking it. And they keep asking for him. And it's like, okay, yeah, he's there. And so I was like, oh crap. And the door was stuck open. And by the way, always there's nothing wrong with that. You can grab your ID and you can lock the door as soon as you step out, and they are required to have a warrant. And so I'm like, hey, you can't come in, door's shut, and all that stuff. And they're asking for him, and it's like, okay, eventually he comes out. And so what had happened was my roommate had participated in a crime, and I had no knowledge of this crime at all. And so I'm like, hey, I'm not letting you in my apartment, not without an actual warrant. Like, you can't just come in. I did have substances that were illegal in my apartment, and they were hidden, but they weren't like, stellar, excellent hiding places. Like, they could have been found with a fairly easy search. And so I'm like, hey, no, you're not coming in. And I'm like, they're like, well, why don't you just let us in? And I'm like, well, I don't know exactly what you're looking for because I have no clue what's going on here. And no, I have a right, you can get a warrant. And they're like, well, we know. And through a discussion between myself, my roommate, and the sergeant who was there, it may have been the sergeant or it may have been one of the other officers. But I'm pretty sure it's the sergeant. They're like, hey, what if we come to the agreement and we write out this document, that we're only going to search his living area and this certain area of the living room where evidence was. He had basically admitted that it was there, but it was my apartment. It was my name on the lease. And so I'm like, hey, no, you're not coming in. Like, you may come in and look for that, but I don't know what else you're going to do in there. And so I want something there that says that you're only going to do this. So they come back with a sworn statement and this deal about, okay, we're only going to search his living area and the specific part of the living room where the evidence from the crime was hidden. And so we did that. We got them to sign this deal. I signed it. It was all like legit. And so that's what they did. And I couldn't even go to the bathroom because my dumb butt had left some stuff sitting out. And if I would have gone through my bedroom, they would have seen it. It would have been in their view. That would have been a felony possession charge. So that could have been worse. Both of us could have wound up in jail that day. And so find what they needed to find, and they took him off to jail. I then spent the rest of the day finding a way to bail him out of jail and to I was cleaning up the area, because once they come in and they search for something, they don't clean up afterwards. Even if they find nothing, they're not going to clean up afterwards. That is your problem. And at least that's been my experience, is that's your problem. So moral of the story is, make them get a warrant, some sort of sworn statement, of what it says, particularly describing the place to be searched and the persons or things to be seized. They can't just come randomly in your home and start looking for stuff. Like, they have to have true probable cause that whatever it is in there, and they have to be going in looking for certain things. They just can't find a bunch of stuff to throw charges on without it being there. It's going to be inadmissible, because that's not what the warrant was for. So protect your rights, okay? Protect yourself, protect your property, all those things. Make them get a warrant. It's your right, and it's your life if things go wrong. So next, we're going to hit on this Fifth Amendment, and it says, no person shall be held to answer for capital or otherwise infamous crimes unless on a presentment, which they no longer do presentments, basically, because it was a thing in the past where a grand jury would notify a court that there was evidence or crime that was possibly committed. And so that was anyways, long story short, they don't do that anymore. It's all by indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without compensation, just compensation. So a grand jury has to formally indict you. You can't be charged twice for the same crime. That's double jeopardy right here. But there's a way around that technically. I'm gonna pull up. Okay, there it is. I've got a Google Doc. Let's zoom in so you can read. It's called the dual sovereignty doctrine. Essentially, the core idea is the federal government and the state government are considered separate sovereigns, each with independent authority to define crimes and prosecution and prosecute violations of their own laws because they are legally distinct sovereigns. A prosecution by one does not count as the same offense for double jeopardy. It proposes as prosecution by the other, even if the underlying conduct is identical. So basically, if a state declines to prosecute and drop charges or acquit someone, federal government can still bring charges. I've got a real world example here. This is all pulled from Claude, by the way. I'm not going to take credit for all this. The real world example in this is the Rodney King case. It's probably one of the most famous ones. So the LAPD officers who beat Rodney in 91, in the state court, they were acquitted, which caused the 92 LA riots. Major deal, right? So then the federal government prosecuted the two officers for violating King's civil rights, in which then they were found guilty. This was possible, but precisely because the state acquittal did not bar a separate federal prosecution. So there they were able to do that. So essentially, it is possible to be charged for the same crime twice. If one drops it and the other one picks it up, it's sort of like if you have like a criminal mischief charge and there's damages and the damages are push it into felony criminal mischief, then the state will probably pick up the charges, where even if the person drops the charges, even if they want to drop charges. However, if it's like misdemeanor criminal mischief, and then the charges are make it a misdemeanor and the person drops charges, then they'll usually drop it. At least that was my experience. That was that was a little bit before the previous story where I had that exact same thing happen. So anyways, there is a way. So next we'll get into nor shall be compelled in any criminal case to be a witness against himself. This is what's commonly known as pleading the fifth. You do not have to say anything that's going to implicate you in a crime. You have the right to shut up. It says you have the right, the Miranda rights says you have the right to remain silent. So if you believe that there's any way that you can implicate yourself in a crime, zip your lips and get an attorney. You don't have to, even if there's a trial, you don't have to get on the stand. You do not have to testify. A lot of times people that are accused of crimes, they do not testify because, if they really did it, then why would you want to get up there and be under oath and risk being caught? So don't say anything. So we get into due process. You will not nor be deprived of life, liberty, or property without due process. Due process is I've got another document here. Let's pull it up. So here we have what due process is, right? That is fair, established legal procedures, adequate notice. So a person must be informed of the charges or the action being taken against them. You'll be served or you'll be arrested. That's a good way to find out is to get arrested. Have your ID ran and find out you have a warrant. That's always fun stuff. Had that happen before. Got into a car wreck. They were obviously running my driver's license. Come to find out, yeah, I had a medical board advisory, and so they arrested me for driving without a license, or my license had been revoked. And so there you go. That's a way to find out real quick. You have a meaningful opportunity to be heard, the right to present one's case, typically before a neutral decision maker. That's in a hearing or a trial. So you get to have a trial. You're supposed to get a neutral and unbiased tribunal. So essentially you get a judge that has no personal stake in the outcome. These are all supposedlies, and possibly, like, just, I mean, justice is not always fair, unfortunately. Well, sometimes it depends on who you know. Especially in smaller, well, actually it doesn't really matter in any city. Then finally, you have the right to confront the evidence and witnesses. So you can present your own defense. You have right to counsel, and you have a right to for that counsel to explore evidence and present your own evidence. So that's essentially what due process is. And if anything happens and you feel like you can win the case, or if you've been wrongly arrested, then fight that stuff. You know, it's important to get a good attorney. Use caution. If you're just like, well, I'll just get a court-appointed attorney. Most of the time, they don't really serve your interests all that well. A lot of times, it's just however they can make a deal and be gone with it, because unfortunately a lot of those attorneys, they have a large caseload and they're just trying to get it done so that they can move on. Of course, they are being paid by the same people that are paying the prosecution's paychecks, so it's tricky. And then finally, your private property cannot be taken for public use without just compensation. So if they steal your stuff, if they take your stuff, they got to pay for it unless it is lawfully seized. Then good luck. If they tow your car, then that's on you to pay those tow bills. So that's going to be it for this episode. We've got 5 more to go in this Bill of Rights. So make sure to hit that like button. Make sure to leave a comment below. Subscribe to the channel. You know, if there's anything that you have gained any type of information, if you found this interesting in the least bit, please support me. Just simply by pressing the like button. That's all you got to do. It takes half a second. So click that thing, and remember, freedom ain't free. Peace. Hey guys, don't forget to set your notifications. This video was originally uploaded from Freedom Ain't Free 1776, an Uncle Sam Presents video. Copyright 2026, Uncle Sam Presents.